County, cause number 19-2-1704-34. The court had previously granted Mr. Green's request to video record this hearing, and so we'll proceed with argument. We'll begin with appearances on the record.
Hi, Colin Gatton, a Civil Deputy Prosecuting Attorney for Lewis County and Board of County Commissioners.
I'm Joseph Thomas for plaintiffs Brian Green and Brian Cortland.
Thank you. Before the court today is the motion for summary judgment filed by the defendants. This is my understanding. My understanding is that the defendant's motion for summary judgment was filed at the beginning of May. After that, the parties reached an agreement that the plaintiffs may file an amended complaint contingent on the county being able to go forward with this motion today. At the end of May, I want to say around May 23rd, the amended complaint was filed during the time that this motion was being briefed. After that, the plaintiffs filed a motion also scheduled for today to strike the briefing and declarations of Lewis County that pertain to issues that are no longer included in the amended complaint, but were part of the original motion. Briefing regarding the summary judgment motion did not appear to be in compliance with this court's rules on timing. And it appeared to me that, in fact, briefing was filed even this week regarding that motion. Given all of those things, despite the fact that the court has reviewed all of these pleadings, I remain confused about the issues that the parties intend the court to address today, because it appears that it's somewhat of a moving target. So I'm prepared to hear argument today, but I wanted to bring the court's concerns to the attention of the parties. It has severely impacted the court's preparation for this hearing today. And I say that with the understanding that I always appreciate the parties talking to each other and reaching agreements. It is not unusual for attorneys to not have a complete understanding of how those changes and agreements might impact the court's preparation. So, given that, what I would like to do is hear from the parties regarding both the summary judgment motion and the motion to strike, in the context of any explanations regarding the procedural posture of this motion before the court today. And although I could hear from either party first, I think I'd like to hear from Mr. Gatton first, the first one to file a motion, then Mr. Thomas. But I wanted to begin putting those concerns out there. Mr. Gatton.
Yes, thank you, Your Honor. So what I believe is in front of the court today has the issues have been narrowed simply to whether or not notice was proper for the alleged meetings at issue.
So I already have a question.
Yes.
You say the issues have been narrowed, and you're stating one issue. My understanding is that there are 10 separate issues in terms of decisions made that the plaintiffs are alleging the Open Public Meetings Act was violated. Are you saying that the county's procedure in putting everyone on notice that their meeting schedule is Monday through Friday, 8 to 5, addresses all of those issues?
No, Your Honor. It's my understanding that when plaintiffs amended their complaint, they removed any complaint allegations regarding decisions made outside of the public view in executive session. However, each agenda item that they are alleging is not properly noticed and was not noticed to the public runs afoul of the Open Public Meetings Act. And so insofar as that, the violations are still, that is the violation that the plaintiffs seem to be alleging, is that there wasn't proper notice to the public of these meetings. They believe that they're special meetings. We believe that they're regular meetings. And that is what I understand to be the issue.
Well, that sounds like a whole lot of issues to me.
Okay.
Am I missing something?
No, you're not, Your Honor. Those are the issues, but I think just to distill it, it's mainly about whether or not there was a violation of the Open Public Meetings Act for failing to provide proper notice. And that is those are in 10 or 13 different meetings.
Okay.
So, Your Honor, there's no dispute of material fact here that as a matter of law, the Board of County Commissioners complied with the Open Public Meetings Act for 3 reasons. The first reason is that on its website, the BOCC gave notice 24 hours in advance of each meeting to the public on the topics on each agenda upon which action may be taken at each open public meeting at issue here, in compliance with the notice requirements for regular meetings and the BOCC's meeting policy. Second reason is that the BOCC did not take action in those meetings.
Excuse me, can you just slow down a little bit?
Yes, I can.
The second reason.
The second reason the BOCC did not violate the Open Public Meetings Act is that it did not take action in those meetings on any topic not listed on the agenda in compliance with its own meeting policy. And finally, the BOCC did not it only took final action on topics listed in executive session during open sessions of those meetings. Given the record, there's no evidence presented that the BOCC did. It is undisputed that the BOCC gave notice 24 hours before holding these public meetings by posting the agendas on the website. The plaintiffs have not offered any evidence to the contrary. To that, it's undisputed in the record that the BOCC gave notice that the topic of Cortland Green QP litigation was on each agenda. I think the plaintiffs agree with that as well. There's no evidence suggesting that that is not the topic issue, and with exception of one other topic, which is monetary judgment. And then finally, because the complaint was amended, it did remove the issue of decisions made in executive session, leaving all other issues on the table, which whenever there's an allegation of a violation of an action under the OPMA, it is the case that notice is an issue, because if it's not properly noticed, you could be making a decision or taking action outside of the public view. So then the remaining are these issues. Whether the meetings at issue are special meetings and not regular meetings, because the BOCC's meeting policy supersedes and is inconsistent with the resolution that was passed setting the regular meeting schedule. And our answer to that is no. And the second issue is whether listing the topic as Cortland Green QP litigation gives sufficient notice to the public of the actions to be taken by the BOCC in these meetings. And as always, when analyzing a question of law, we've got to look at the plain language of the statute. RCW 4230.070 says that a governing body of a public agency may set regular meetings by setting the time and date in either an ordinance, resolution, or bylaw. Here we have a resolution that sets the times of regular meetings from 8 to 5 p.m. That is when they could be scheduled. What's in the record here, there is no definition of what a regular meeting is other than that it's set by law or rule. This is set by law because it's a resolution. This is in compliance with that statute. Now, I take plaintiff's point that if that's the only piece of compliance for regular meetings, that could mean that there are continuous meetings, but the record shows that that's not the case. The record shows that there are agendas for each individual regular meeting that we have that has been posted on the website. It also lists the location of those meetings on the website. And so for that reason, it appears as if these are regular meetings. And we have properly noticed all of these meetings because we have provided 24 hours notice of each and every one. The second issue, although the plaintiffs maintain that this resolution is superseded or inconsistent with the policy due to an implementation of additional meeting policy, that's mistaken. The record demonstrates how, in the declaration of Reva Lester, demonstrates how in effect they work together. So what the meeting policy does, it allows us to, it provides us a standard for what we have to post, what we have to say for each and every meeting. And that's exactly what we complied with here. The previous litigation, which is in the record before you, has all of the offers of judgment and the stipulations and the judgment that was entered, doesn't say or doesn't require that the resolution is superseded. There's no evidence in the record that has been superseded, and for that reason, it is still in place and is still a regular meeting, and it still works together with the meeting policy. And there's no dispute here that the meeting policy was complied with appropriately. So moving to noting the meetings for discussion in executive session for Cortland Green PP litigation. The public is on.
What do you mean when you say noting?
So on the agenda, it lists the topic, and the topic is.
So you mean posting the agenda?
Right. So the agenda provides the topics to be discussed in or take action upon in an open public meeting. And so long as those are on the agenda, based on our meeting policy, we were able to take action on those items. Cortland Green QB litigation tells the public that that is a topic that we are taking action on in that meeting. There's no limit, because executive sessions occur during open sessions at regular or special meetings, there's no issue in then.
Did you say regular special meetings or regular or special meetings?
Regular or special.
When are special meetings?
So special meetings occur when, for the Board of County Commissioners, they occur outside of the schedule of the.
So basically, outside of normal business hours is a special meeting.
That's correct. Or if it's at a different location. So usually we have our meetings at the county seat and the county courthouse. Our policy says that if it's at a different location, we need to note that location. And so that's what makes it a special meeting. Moreover, what you have to do to provide notice for a special meeting is you have to notify all of the news media that you're going to do that. You also need to post the agenda's website. You also need to note the business to be transacted. But the meeting policy itself that we've adopted doesn't necessarily have all of the conditions for special meetings, so it doesn't necessarily supersede the resolution. It only supplements.
Is it your understanding that the issues that remain as part of the allegations in the amended complaint include violation based upon special meetings?
Yes, so they've alleged, they believe that the meetings at issue are special meetings, not regular meetings. Our position is that they are regular meetings because we've complied with the statute to set them as a matter of law.
And that's because they were scheduled Monday through Friday between 8 and 5.
That's correct. And that, again, notice was given properly 24 hours in advance for each and every meeting within that time frame. So whatever meetings we have within that schedule are those regular meetings. The issue in 2017 in the litigation was, in fact, that we were not doing that, and we were not providing those agendas for those meetings. Rather, it did lead the plaintiffs to believe in that case that the meetings were continuous throughout the day, and it didn't fit the spirit of the Open Public Meetings Act. This meeting policy allows us to actually meet the spirit of the Open Public Meetings Act by, one, restricting the decisions we can make in regular meetings. We can only make decisions on those things that are on the agenda. And two, requiring us to post the notice and the time and the place and location of those meetings on the website, which the record indicates that that is what has happened here. Insofar as the listing of the topic, Cortland Green Hupy, and whether that is deceptive as to the business to be transacted. The business to be transacted is just whatever action is going to be taken in that meeting. So if it's listed on the agenda, we can take action on it. The executive session statute does not contemplate that you cannot then come out of executive session and return to open session and make a decision at a later time. The public is on notice that that is a topic for which we would take action on, both discussion and potential action, and so long as that's done in open session. And that's in fact why that's relevant. That the evidence about whether or not we complied with the executive session statute is relevant, is that it does demonstrate a level of compliance that we intend to comply with the OPMA, which also leads to an affirmative defense that we did raise, which is that even if there is a violation here, there's no knowing violation, because it's clear from the record that the Board of County Commissioners don't intend to violate it. It appears as if they've done things to create layers of compliance so that sufficient notice is given to the public of what their actions are going to be, both with executive session, because in fact, the OPMA does not require you to list topics that you'll be discussing in executive session. It only requires you to list the reason for executive session on an agenda, and so you're announcing it to the public both on the agenda and in the meeting itself, when you enter, and how much time you take. I'd like to reserve the rest of my time to respond. If there are any further questions that you'd like to ask now, I'm happy to answer those.
Did you want to address at all the motion to strike?
Yes, Your Honor, I believe I did with respect to my argument as to, in essence, how the evidence is relevant. So first, it is relevant in the sense that it does show an intent to comply with the Open Public Meetings Act generally, which is important to know insofar as the issue is whether or not there was a knowing violation. It directly speaks to that. Secondly, it also speaks to that we have what we've created here is a culture of compliance to make sure that the spirit of the OPMA is followed, both in session and out session. And thirdly, it's relevant because they are complaining about issues about executive session topics, and so it's still relevant insofar as the facts alleged. Finally, it does show that, in our opinion, that this was brought frivolously and without reasonable cause, because the meeting minutes are publicly available. We could have received those before even bringing this. They chose instead to amend the complaint to drop that once they received evidence demonstrating compliance with decisions made in open session for each meeting that they did complain about. So that's why that's relevant and shouldn't be stricken.
Thank you.
Sure.
Mr. Thomas.
Thank you, Your Honor. Let me address the record because I believe that it's a mess. I believe that Mr. Gatton said to this court, I think both our parties now at least believe that the issue before the court is whether there was sufficient notice of the meetings alleged in the amended complaint. And in fact, the amended complaint alleges a few more meetings that were revealed through discovery than the original complaint. And so those meetings are what are at issue today. What happened was, when the lawsuit started out, plaintiffs believed that these actions happened in executive sessions behind closed doors. We had evidence that was in the original complaint that we had a reasonable belief in order to come to that conclusion. But through discovery and through defendants' assertions, plaintiffs realized that they were mistaken, which happens through discovery. That's the point of discovery, is to flesh out the facts of the case. And we realized that these actions were not taken in executive sessions. It appears that defendants actually did comply with the Open Public Meetings Act for executive sessions, and they talked about the issues, and then they came out and they voted. And this is important because defendants, they admit that they aren't allowed to vote in executive sessions. This is demonstrated in the declarations of Defendant Jackson, Defendant Stanford, and Defendant Funn. They all say that, look, we know that we're not supposed to vote. We come out and we vote. and the law precludes them from voting. And so what is at issue today, Your Honor, is whether they gave sufficient notice about votes in an open session or public session. I think those words are being used interchangeably. Because they're not allowed to vote in an executive session. So plaintiff's argument is that when defendants only give notice of executive sessions, they're not giving notice about a vote. Because it's agreed that nobody's allowed to vote in an executive session. So if they're only giving notice about an executive session, as Mr. Cortland, Mr. Green, and Mr. Hoopie testified, as the public, they are the public, and they're the only public that's testified here. As the public, how are they supposed to know about actions that are being taken by Lewis County? And these are final actions. This isn't just deliberations. These are final actions of motions and votes. And that's why the summary judgment shouldn't go through today. We're talking about two different issues. As was in the motion to strike, defendants argued the entire motion for summary judgment about executive sessions, which was understandable. But then the issue morphed into, as discovery and as the parties talked, the issue morphed into whether there was sufficient notice of these open session and public session actions. Your Honor was the presiding judge on the previous Open Public Meetings Act lawsuit, where Lewis County and defendants, the same named defendants in this lawsuit, admitted a violation of the Open Public Meetings Act through a signed CR 68, that they violated the Open Public Meetings Act by not giving sufficient notice. And defendants even took the remedial step of crafting their own meeting policy based upon that admitted violation of the CR 68 that said that they would give accurate notice of all meetings. And so when defendants talk about regular or special meetings, that has some significance, and plaintiffs do argue that these were special meetings because, first of all, the 2009 resolution that defendants used, first of all, isn't being followed. I think that's pretty clear from the record and from plaintiffs' arguments, and I think that's uncontested, that it's not being followed. They're not having meetings from 8 to 5. They're scheduling meetings at different times and different meetings each week.
So I have a question about that. And this gets to my comments at the beginning. How would you describe the issue with regard to your challenge, if there is a challenge, as to that policy?
I'm not sure if I quite understand.
Well, I think I heard you say that your argument is that the policy, I hope I'm using the right word, the policy of the county, that their meetings, their regular meetings are Monday through Friday, 8 to 5 every single day. Are you challenging that?
Yeah, yes, that is being challenged, Your Honor, and let me address you, let me point out to where it is in our briefing then.
Because I'm trying to get to the claims in the amended complaint. That's one of the things I'm really struggling with. The parties are indicating what the issues are, but it seems to me that it's a moving target, and I am trying to establish the issues and sort of the order in which the court must address the issues. If that is a threshold issue, and I'm not saying it is, but if it is, that's what I'm interested in hearing from you.
So let me explain. I would really like to answer this court's question, and I'm trying my best. So if I do not answer it, please ask me again, because I'm going to give it my best effort. So there's the 2009 resolution, which says that they're going to meet from 8 a.m. to 5 p.m. And then they entered into this 2017 policy, which clarifies the meeting notice. And this is our real issue, is that, look, they need to give accurate descriptions of all their sessions. And so the 2009 resolution, in plaintiff's opinion, only comes into effect is that it conflicts with the later meeting policy, which should supersede it. So does that answer your question, Your Honor, about
yes.
if it's an issue?
So if I understand correctly, you're not independently challenging the 2009 resolution, you're challenging the 2017 policy.
Yes, Your Honor.
Thank you.
So we're challenging the 2017, and I apologize that was unclear. So we're challenging the 2017 policy, and actually we're not challenging the policy itself. We think the policy is perfectly valid. It was agreed by both parties. It was entered into this court. Your Honor was the presiding judge in that case. And we think, and there's no argument that it somehow violates the OPMA or that it's somehow invalid.
So another question somewhat related, and again, this relates to the court's review of the amended complaint, which has an attachment to it. Are you saying they've violated a contractual agreement? Because it seems like you're not actually challenging that policy either, but basically saying they haven't followed it.
You're correct, Your Honor. I think that you summarized it very well, but we're saying that they did not follow the policy, and their policy clarifies their duties under the Open Public Meetings Act. And so when they did not follow their policies, they violated the Open Public Meetings Act. Because we stipulated, they said that they would take remedial steps through this policy. And remember, this arose out of an Open Public Meetings Act violation. And they said, here's what we're going to do in order to comply with the Open Public Meetings Act in the future. And they didn't do that. They didn't follow it. And let me point this court's attention to page 8 of the reply brief from the defendants. And I'm going to read two paragraphs here, the first and second paragraph of page 8, because I think these are important. Moreover, plaintiff's argument misunderstands the practical reality of an agenda. The county enters meetings on litigation without yet knowing what specifically it will discuss. The VOCC is not allowed to pre-deliberate for the meeting to see if it will wish to make a decision regarding legal strategy. This is true for other agenda items too. For example, on November 6th, 2018, an agenda item was listed as, quote, staffing, end quote. There's a citation. The VOCC would not know what exactly they will discuss or decide about staffing. But the public knows that staffing is a topic on the agenda and that the county business may be transacted on staffing. If the public would like to know more about staffing of the prosecuting attorney's office, they may attend that meeting, exclamation mark. And there's more to the paragraph, but that's the pertinent part. Lewis County and defendants admit that they don't know what they're going to talk about. They're just giving general notice. And plaintiff's argument is this notice is not reasonably calculated in order to inform the public. We have declarations from the public stating that the public doesn't know what defendants are going to talk about. Defendants use this broad moniker, this broad canopy, a lot of times, of Cortland, Hoopy, Green litigation, and a lot of times they only talk about Mr. Cortland or Mr. Green. And it leads the public into a false sense of understanding that they're going to talk about all three of them. And as a point of clarification for this court, because so that we're all on the same page, there is ongoing litigation with Lewis County with all three of those men, Mr. Cortland, Mr. Hoopy, and Mr. Green. This case is currently on appeal in the Division II Court of Appeals. And so it would be perfectly understandable for the public when they see all three of those men's names together repeatedly to think that they were talking about that specific litigation. There is not a case number. There is no other identification about which litigation that Lewis County defendants are talking about. And then moreover, going back to the legal issue that was discussed before, the public only knows that defendants are talking about in an executive session where votes and motions can't be made because that's deliberation. Or, I mean, that's a final action. And that can occur in an executive session. So there's misleading notice to the public, and then there's incomplete notice to the public about what's happening. They're not telling the public that they're going to vote on anything because they're only mentioning it for executive sessions. And then instead of, defendants mentioned in their example on November 6th, they talk about, quote, staffing, end quote. Is that staffing for Ms. X, is that firing an employee? Is that hiring an employee? Is that the rules governing for when lunch breaks are taken? Staffing is a very, very general description, Your Honor, and none of these descriptions are reasonably calculated to give the public any notice. And defendants repeatedly state in their arguments that the notice is supposed to be for the public. Just a second, and I will give some. On page 5 of the opening motion for summary judgment, actually not on page 5. Let's go to page 12 of the opening motion for summary judgment. In the second paragraph, there's a sentence that states, "This is Lewis County's way of serving the purpose of the OPMA, which is to ensure that the public can, quote, observe all steps in the making of government decisions," end quote. The notice is for the public, and they're not giving notice to reasonably calculate to what the public should know. They only make broad statements or conclusions that there is public notice. And there's no dispute, Your Honor, about whether there's agendas for these meetings. There's no dispute about whether they have these meetings, but there is dispute about what the public could know from the description on the agendas for these meetings, because it is for the public to show up, and it is for the public to know so that they can figure out if they want to attend. And each of the three men of the public said that they can't even figure out what's happening in order to attend. They thought that the only thing that was happening was a closed-door executive session with their attorney, where decisions were being made, but in fact decisions were being made in public. Why would they attend? Why would Mr. Cortland, Mr. Hoopy, or Mr. Green attend any of these meetings when they think that it's just a closed-door session with their attorney that they're not going to be able to attend? There is no identification whatsoever in the record that these that any action would be taken in the public. And in fact, defendants seem to omit this when they say this is double notice. They talk about it in their reply brief. They're not required to give double notice. Well, double notice would imply that this is the same thing occurring twice. Well, we're going to have two executive sessions on the same topic. Or we're going to talk about staffing in the open session twice, something that occurs twice. But that's not what's happening here. These aren't closed-door sessions with their attorney where no votes are being taken. We're talking about public or open sessions where votes are being taken on litigation that affects things. Yes?
I have a couple of questions.
Okay.
Again, and I apologize for these questions. I'm really trying to understand the issues here. And I guess I begin with the statement that you made. This record is a mess.
Yes.
So that's why I'm continuing to come back to what are the issues before the court, because the motion was filed when a different complaint was the operative complaint, which is why the court's struggling. So with that, do you agree that no final action was taken in executive session?
Yes, we agree.
Okay, so that's not an issue for this court. That's conceded.
Yes, Your Honor. In fact, we said that the words executive sessions don't show up in the amended complaint.
Okay. Do you agree that notice was proper for all executive sessions?
No, Your Honor. And for instance, I made the statement that Cortland Hoopy Green litigation, and they keep talking about Cortland Hoopy Green litigation. And I'd have to check my notes exactly, but on November 28th, I believe, they were talking about CR68, the fourth CR68 for Mr. Green, or any of the CR68s for Mr. Green. And they talk about Cortland Hoopy Green litigation, but they're only talking about Mr. Green. And defendants keep pointing out the meeting minutes are in the record, and if this court looks at the meeting minutes, it identifies the only litigation discussed was about Mr. Green on those dates.
Okay, so I think I'm understanding. One of the issues from your perspective is the content of the notice of certain meetings regarding executive session, the content of the notice.
I'd like to clarify real quick. So the executive sessions only matter is that what happens in public. So we're not talking about the executive sessions anymore. We're just saying nobody has notice of what's going on in public. And defendants are saying, look, we gave notice through the executive sessions.
So I'm going to go back to my last question.
Okay.
Because I asked you whether notice of executive sessions was adequate, and you said no.
Yes, the notice of executive sessions is not adequate.
Okay, and then when I said what you're challenging with regard to the notice of executive sessions is the content of that notice, and
Yeah.
then you said, well, no, it relates to the decisions that are made after they're no longer in executive session.
Yes, so,
I mean, I think I understand your argument with regard to this. If I read the record, let me just try to summarize your argument. I think what you're saying is that the county's attempt to comply with the 2017 policy was to provide notice that there will be 1 or 2 executive sessions where the Cortland Green Hoopie litigation is going to be discussed. And that did not provide your clients with notice of non-executive session meetings at which decisions would be made.
yes, Your Honor, I agree with that.
Okay, so I thought I was following you.
Yes, Your Honor, thank you.
So your challenge is to the decisions made in open session after the executive meetings were over.
Yes, Your Honor.
So I'll go back. You're not challenging the executive sessions or what occurred at executive sessions.
We are not challenging the executive sessions or what occurred in the executive sessions.
And your challenge with regard to the notice of executive sessions is only for the purpose of challenging the open sessions after the executive sessions.
Yes, Your Honor.
Okay. Thank you for your patience with
Yes.
me.
Thank you for your patience, Your Honor. I apologize for the clarity of the record. We're trying our best too.
Indeed.
So the notice, we both agree that the notice was never really addressed in the motion for summary judgment. In fact, defendants pass over notice. They do talk about it in 2 pages, I believe from page 10 to 12 in their motion for summary judgment, but it's not discussed there. They don't discuss whether they gave notice of these specific actions as we're alleging in the amended complaint. And to go back to this court's initial question to defendants, it would be best served if this court clarifies the issue and then we go back and have proper briefing on this issue so that there's a clear record about what we're talking about, because I think with everybody's best intentions, we're just talking past each other because this is a factually complicated issue. And so plaintiffs would suggest that we go back and we have briefing on the issue and we have set dates, and then we come back and we argue the notice to this court.
Thank you. Mr. Gavin.
Your Honor, I think if the challenge is just to whether or not the county complied with the meeting policy, of which it does follow, I think that the key point to note here is that it says that on agenda is the part 2, it's on page 5 of the offer of the judgment upon stipulation of parties, which is in the record. It just says that no additional topics, that is, no additional topics other than those on the published meeting agenda shall be discussed or acted upon by county commissioners at any meeting. And so then how action is defined by the Open Public Meetings Act. And action is very broad and includes decisions, discussions, public testimony, depositions, anything that the entire body is going to do, including final action. And the statute for executive session says that holding an executive session shall not preclude other things from occurring during a regular or special meeting, which is the case here. It's listed, the topic is listed on the agenda. The agenda topic is that we're going to be, in executive session, the discussion is going to be about litigation. And then that puts the public on notice that an action may be taken, not just discussion, but final action, because it is a regular meeting we contest. And it is an open meeting that was properly noted. That can't happen once we exit executive session. So in essence, it doesn't require us to double note. Secondly, the practical reality of the the specificity that the plaintiffs require wouldn't allow the attorney to speak with their client about any topic related to any of the litigation that they're handling, because that is the time for them to freely ask questions, to understand what's going on, to obtain that type of representation that non-public entities also enjoy. And so, go ahead, sorry.
Sorry to interrupt, Mr. Gatton. Wouldn't it be true that a government's practice in this area would be to provide broad notice to the public, even if a particularly specific topic wasn't discussed, but could be discussed, that the county would put that on the agenda to indicate to the public, whether in open session, a special meeting, or exec session, the practice would be to be overly inclusive, even if a topic didn't actually get reached.
Yes, Your Honor, and that was the second point I was about to get to. So even in open session, if something is listed with a broad general topic, that just provides the public notice that they can come. That is something that the county commissioners or the other governing body would be discussing. And more importantly, if it were to be so narrowly defined, we could not, based on our policy and under the Open Public Meetings Act, we could not discuss anything other or take action on anything other than the narrow issue. And so if there were questions from the public even, or from the Board of County Commissioners to the persons in the room about that topic, that goes a little far afield. I mean, it's still about staffing, but it's talking about staffing of another individual in the office, then that would be the case that we would have to say, no, we can't talk about that. We're going to have to set that for a different meeting because we can't answer that right now.
Mr. Gatton, do you agree with what I discussed with Mr. Thomas regarding the issues and how they've been narrowed?
Yes, I do. I wanted to address on one other piece that you did discuss. You mentioned executive session. So there were just discussions in executive session and non-executive session. So the decisions made in non-executive. It is still the same meeting. Executive sessions occur inside the same public meeting. And it's not a separate meeting. It's just a meeting closed from the public for certain narrow issues. And one of those here is pending and ongoing litigation. And it's clearly relevant here to have executive session so that the attorney can discuss those issues. But to answer your question in a shorter manner, yes, I agree with it, but for that.
And I appreciate that. My intention in stating the issues was not in any way to give rulings or to state how the court is thinking on those issues, just to restate them from the perspective of the parties.
Right, thank you. And so I think that because that is the issue, I think it's the case then that that I need to return to the regular meeting piece, because I want to make clear to the court why, in essence, the county commissioners can do this, or why a governing body of a county can do this. Is that there's nothing that defines a regular meeting in the code. It just says that you have the freedom to set them at whatever schedule you would like. It doesn't define them by title. It doesn't define them by content. It only separates meetings, the OPMA does, between regular and special meetings. This policy applies to both. That the Board of County Commissioners adopted. They have given layers of compliance to provide notice to the public to know when they're meeting, what the general topics are that they're going to discuss. They've substantially complied with the meeting policy, which is what was required from the judgment that was entered, was substantial compliance with that policy. And this record shows that there's no dispute of material fact that that is the case, and we're entitled to judgment as a matter of law. Thank you.
Thank you. The court is prepared to provide some direction to the parties at this time. I very much appreciate this discussion today. I also very much appreciate that the parties have been working together to narrow the issues in this litigation, and that is occurring up until today. I appreciate that. However, it's challenging to the court to determine exactly what the issues are that we need to address. And the court is inclined to allow the parties to further brief the issues that I believe are really before the court. And I apologize if it's my lack of understanding that has caused us to be here today. But I believe when what was initially briefed was a different complaint, I've actually never had this situation before. It makes it very difficult for the court to be prepared to address the issues that are changing as things go along. It is not unusual for the issues to narrow while the briefing proceeds in summary judgment, but as I said, it's highly unusual, in fact unique in my experience, for the parties to agree to completely different allegations, claims, and an amended complaint while the parties are briefing summary judgment. And the briefing didn't conclude until just 2 days ago, which is not normal for a motion for summary judgment. So I believe that the issues at this point are narrowed to the compliance as to the 2017 policy, and there may be several sub-issues associated with that, and whether the notice for each of the meetings and decisions made at the meetings in the amended complaint comply with that 2017 policy. I believe that the parties agreed that if the 2017 policy was complied with, that there would be no violation. So that essentially becomes the issue before the court. And I believe that that issue needs to be addressed in the context of each of the challenged decisions/meetings. Again, I appreciate that the parties have attempted to narrow the issues, but I believe that the court requires new briefing, and I would say substituted briefing that is addressed specifically to the allegations in the amended complaint. Do the parties require further clarification?
Your Honor, no. I would ask if we could set a briefing schedule today, if possible, so that we can proceed.
So here's what I'd like to do if the parties are in agreement. What I'd like to do is see if the parties could go down to the administration and obtain a date for a dispositive motion, and then work backward from there with a briefing schedule. Would that be agreeable?
Yes, sure.
Thank you.
Who would you like to have the first brief? Or would you like cross motions or how?
I think that it's the county's motion, so that's how I think it should go, unless there are going to be cross motions. The parties can talk about whether they want different briefing. Personally, I'm okay if the parties want to file 2 briefs each. I don't think simultaneous briefing is helpful, because then the parties can't respond to the other's arguments. But I'll let the parties confer regarding an appropriate briefing schedule. I would ask that the parties comply with that briefing schedule for the court's benefit. So with that, I'll just allow the parties to go talk to Mr. Bales down in court administration for a date. He may be able to assist you in actually drafting an order that sets the hearing as well as a briefing schedule for that. Does that make sense?
Yes, sure.
So I would like to make sure that we have an order before you leave the courthouse today. As you probably heard this morning, sometimes we struggle with an oral ruling that is never put into an order, and then the parties have trouble remembering what occurred, and that causes some difficulty. So let's make sure that we either go back on the record or the court signs an agreed order today, okay?
Okay.
Thank you.
Thank you, Your Honor.
Anything else for today?
No.
Thank you very much for your time.